Alex here with part 222 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the order dismissing appeal. My mindset was disappointed, but I understood why they did that. This is a very complicated issue. When you're in a child custody case, a tremendous amount of that case is in the post-judgment phase, which in Nevada is tricky when it comes to appealing. If you're trying to file an appeal to a post-judgment order, you have to show that it is a special order after judgment, which is in and of itself another super complicated thing. I did a separate video that talks about special orders after judgment to help people understand how that works so they wouldn't make the same mistakes that I did. All it does is underline the issue of unnecessary complexity and also explain why so many non-attorneys don't even try and do this stuff. Again, I'm not complaining because I understand why they did what they did. I don't understand why they have these rules in place because it seems to me like they're not necessary, but they do have these rules in place. And if something is not appealable, then you instead have to fight it with something known as a petition for writ of mandamus, which I did go ahead and do. And that'll come up, I think, maybe next video or the video after that. But we still need to go through this. It's still a learning experience for the viewers. It's still going to help a lot of people because I've already gotten some messages from people on how they thought when they couldn't appeal, there was just nothing they could do. And really, there is something you can do. It just has a different name. Instead of calling it appeal, you call it a petition for writ of mandamus. But yes, let's go ahead and go through this. And all that being said, let's go straight into what the Supreme Court has filed. We have the Supreme Court Clerk's Notice of Potential Dismissal. I get these quite a few times in my videos, and all I would do is just send the filing fee to the Supreme Court directly, which I did do. So you're going to take a look at this standard form, but they just send these out automatically to anyone who hasn't paid the filing fee, and you have to pay within a certain amount of time. So I ended up paying this filing fee, and the case proceeded. Certificate that no transcripts are being requested. This is just me stating that there is no hearing that was held in the lower court for me to even ask a transcript from. And so I'm letting the Supreme Court know that I'm not going to ask for any transcripts because there aren't any. My motion was denied summarily, which means without a hearing. And so that makes it cheaper for me to appeal, which is good. I talk about the certificate, actually there's another name for it. It's called the transcript request form. I talk about the transcript request form in another video, and I think that's the video titled Filing an Appeal. Docketing Statement. I've gone through these a few times, but I'm not going to skip it. It's a pretty important document, so we're going to go ahead and scroll through this. I'm just identifying the judge as Bridget Robb. No attorney is filing this document. No attorney is representing my ex. The disposition was special order. So I'm wrong about this. I'm saying that this is a special order after judgment, but I'm wrong. And I explain why I'm wrong in the video Special Order After Judgment. Please watch that video, guys. It explains how this complicated thing works, and it'll hopefully help you, even if you're not in Nevada, understand the complexities of figuring out how to file your appeal, which is crucial when you're going through one of these family court cases because the judges just aren't used to being reviewed, and sometimes the only way you can get justice is by intervention from a high court. Child custody, I don't know why I marked this box because it's just asking, yeah, it doesn't really concern child custody, so I wouldn't have marked this if I had the experience then that I have now. Nature of the action, what is this here? Appellant sought to examine SCDU and for a judicial determination that I was entitled to my ex's assets held in the custody of the Unclaimed Property Division. Both requests were consistent with proceedings supplementary to execution and sought by motion. The district court summarily denied it. Issues on appeal, whether a judgment creditor is entitled to examine SCDU and whether a judgment creditor must exhaust administrative remedies. Oh wait, I already did this. Okay, okay, I see what I'm saying. Whether a judgment creditor must exhaust administrative remedies by filing a claim seeking a judgment debtor's property held in the custody of the unclaimed property division. Next we have pending proceedings, none. Constitutional issues, NA. Other issues. Does this appeal involve any of the following issues? So issue of first impression and issue of public policy, which is true. There's no case law on Nevada that discusses doing this. There is case law in Florida, and I mentioned that, but none in Nevada. And the reason I mention it's an issue of first impression is because there's no case law. And also I mentioned it's an issue of public policy because if a case did publish on this, then the Child Support Enforcement Division would be able to go and start seizing money out of the Secretary of Treasury to satisfy child support payments. And I think I mentioned this here. Let's see. Yeah, it would create an additional stream of income which could be tapped to satisfy child support payments. Assignment to the Court of Appeals or retention. I think, what is this here? I'm saying that it should be retained by the Supreme Court. I guess so. I mentioned that the state of Florida has dealt with this issue, and I mentioned that an expansion of case law would allow the District Attorney's Child Support Enforcement Division to seize money held in the custody of the Unclaimed Property Division. Trial. NA, judicial disqualification, none. That's for if you want a justice to recuse themselves from being on your appeal, from presiding over your appeal. Timeliness of the notice, it's, let's see, appealed from December 6th, and I filed the notice of entry on December 6th, and I filed the notice of appeal on December 30th, which is timely. The rule governing the time limit for filing the appeal is NRAP 4 sub A1. I think it's just a generic 30-day that applies to almost everything. Appealing, let's see, specify the statute or authority that grants the court jurisdiction to review. So here's me citing NRAP 3A sub B8, and this is a special order after judgment subsection. And as I mentioned earlier, this does not apply to this appeal, which is why it gets dismissed. Explain how each authority provides a basis for appeal from the judgment or order. A post-judgment order that affects the rights of the parties growing out of a final judgment is appealable. Okay, so here's why it doesn't apply. It does not actually affect the rights of the parties growing out of final judgment. That 1, 2, 3, 4, 5, 6 words, those final 6 words, growing out of final judgment. That's why I can't appeal it under this rule. Yes, it does affect my rights because I'm not going to be able to collect the money that's owed to me. And yes, it is a post-judgment order, but it's not affecting my rights growing out of the final judgment. It's not. The only rights that are growing out of the final judgment are awarding custody, legal and physical, and perhaps the child support orders and stuff like that. And not perhaps, for sure. But what I'm trying to do is I'm trying to get the judge to give me a designation that money held by the Secretary of Treasury is mine, and I'm also trying to get permission to examine SCDU. These things aren't mentioned at all in my final judgment, in my custody order. So these rights, which I do have, are not growing out of the final judgment. They're just separate from the final judgment. That's why I can't appeal it as a special order made after final judgment. That is what I talk about in the video, special orders after judgment. There's probably more stuff in that video. Definitely recommend taking a look at it. List all parties involved in the action. So that's me and my ex. Give a brief description. Post-judgment motion for proceedings supplementary to execution summarily denied. If you want to know more about this, I talk about this in the video execution and asset seizure. I talk about what these proceedings supplementary are. Did the judgment or order appealed from adjudicate all claims below? Yes. If you answered no, complete the following. NA. So I didn't answer no. I think that's everything. Yeah, here's the verification, which is just me signing, and the certificate of service indicating I mailed this document to my ex, and then the attachments. So the attachments are just the filings in the lower court. I'm not going to go through these documents because I've already gone through them. Standard policy within my docket series is I don't go through things more than once. If you would really like to take a look at this docketing statement for yourself and you want to comment on it, whether you do or don't want to comment on it, you can always go down in the description below, click on the link, download it for yourself, take a look. And then, of course, if you do want to comment on it, just mention something down in the comments below if you think I missed something important. Instructions. let's see, notice regarding deadlines. This is just the generic instructions that they mail out to anyone who's not an attorney that's filing an appeal. I've gone through these before. It's the same standard form. Nothing is filled in, nothing is signed. It's not legal. It's just instructions. So I'm not going to bother going through this. Same thing as I mentioned before. If you really want to look at these instructions, just click on the link, download it, take a look for yourself. If you have any questions on this form, go ahead and mention it in the comments below. Order dismissing appeal. So here is a Supreme Court. They're indicating that review of the notice of appeal reveals a jurisdictional defect. I filed the underlying post-judgment motion as part of an effort to execute on a judgment for costs. No statute or court rule allows for an appeal from an order denying such a motion. Let's see if they talk about, yeah, here we go. Take a look. So Gum v. Maynor, they're saying that a post-judgment order must affect the rights growing out of the final judgment to be appealable. So because it doesn't affect my rights growing out of the final judgment, I cannot appeal. It affects my rights, but it does not affect my rights growing out of that judgment. It makes sense now. I understand why this happened. And I think that's everything. Yeah. Okay, so this was dismissed, which isn't saying that the judge got it correct. They're just saying they lack jurisdiction. So if they lack jurisdiction, they can't even consider whether the judge was correct or incorrect. They just can't. They're just not allowed to. Remittitur. This is the Supreme Court clerk telling the district clerk that this issue has been resolved and that they are sending the case back to the district court. If you want to learn about the significance of the remittitur, please watch my video on the topic, Jurisdiction Divested on Appeal. Going into the aftermath, I filed, let's see, a notice of, no wait, that wasn't me. I filed 1, 2, just looks like 2 documents. They were free filings, so I incurred $0 in costs. Max didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. Max didn't have an attorney either, so she incurred $0 in attorney fees as well. As my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.